Hey, it's your old buddy Brian Parker. Got another good one for you. Today it's a creditor lawsuit defense again. We've done discoverbank previously. I think we did one called How to Hack a discoverbank. There it is, discoverbank video, a number of other things. If you go to the creditor section, defense section on my membership website, you'll see tons of ways to defend against a creditor lawsuit, and you'll also see the evolution, meaning I started this about a year or so ago, and so many new things have come into play that help, that I'm starting to like creditor defense lawsuits a lot more than I used to, because they were so tough given how restrictive it was, because there was very few options. Now, not only are the options good, but those options that were normally only creditor defenses are bleeding into debt buyer defenses, but that's another video. So today's against discoverbank. So if you were sued by discoverbank, what's to be done? Here's my tagline: build that counter affidavit. You know, I preach, you have to listen, but it's the truth. When I'm in front of a jury, I keep repeating the same thing and the same thing. So suddenly I'll repeat it again. I'll look over, I'll see a lady mouthing the words with me. I know I'm done. So that's what I want you to remember. Build that counter affidavit. So top things we want to remember today, if you're going to hold on to anything, Shazam. Look at the pleadings. Is the word debt used? You will not see it in the lawsuit or the affidavit they attach. With this proviso, I'm going to show you one where they did use the word debt. You're going to go, no, that'll be to your benefit. So 2, look at the contract. Is there a governing law provision? It will look like, well, it's already up there. It says this case should be brought in Delaware, but you're probably not in Delaware when you're reading or watching this. So what's to be done with that? Build your counter affidavit. Number 3, does the lawsuit say it's from a Discover bank, but then say there's the Discover products or DB servicing? What does that mean? It's all about the securitization of it all. Who is going to collect for the secure trust? Discover Bank, but it's wound its way through all these trusts. So look for also on your caption clues. Caption is where plaintiff is this person, defendant is you, the debtor. So look for something that says Discover Bank, CO Discover Products Inc. What is that? Look anywhere you want on your contract. You're not going to find anything about Discover Products. So there's a third-party aspect to that. Explore that. In fact, I think you see up there, I've got a number 4. It's not number 4, but it's a paragraph. You can see that's the debt collector, excuse me, the creditor plaintiff saying, yeah, we're it, but you may want to check out these other guys that had part of this. So why is that? So number 4, is the lawsuit a breach of contract lawsuit without the original contract? They will never have the original contract. There's case law in certain states that's saying you kind of don't need it, but then they set themselves up for building blocks that you can just knock down when they go to try to make something true by using more stuff. More stuff to defend or present their case means more stuff for you to blow away in front of the court. 5, does the lawsuit only reference an account and not the word debt in it? Securitization of it all, hello. So get the lawsuit in front of you. But before you do, if you know it is coming, what are my 2 things I've been building the counter affidavit with and your defense and your case? Those great securitization letters and the creditor validation letter, they'll be attached to this membership website. So collectionstoppersolutions.com is where you go to not only get this video, but to get all the templates that you can use to go into battle with these guys and present yourself the best option to settle, to eliminate the debt or greatly discount the case with your use of my documents with your state law and facts. But you want to first and foremost send out those letters. I've attached them to this video and several other videos on the membership website. They're awesome, but you got to build your counter affidavit. So how do you do that? Well, look at all my account stated statute videos, building your counter affidavit. Here's a free PDF. Counter affidavit, account stated videos, they're all on this site. And I'm somewhat, again, repeating what I have to say so that you will mouth the words as I'm saying them. Then you will incorporate them into your psyche as you take on these big guys. So first, as you know, we always look for the linchpin in the lawsuit, and here we go again. Go look at my linchpin videos if you wish. They're kind of fun, actually. Again, the evolution of this site, of my service to you, truly, is that I'll be doing a video and then suddenly something will pop up and it'll come out like I organized it, but I didn't. And linchpin was one of those things. I was looking at the video one time and going, oh, we were going over a lawsuit, and it appeared to me that every lawsuit rested on just 1 or 2 paragraphs, even though there was 12 to 20 paragraphs. So that's the linchpin. You knock out the linchpin, you knock out whatever is the linchpin is dependent upon. So in this case, let's put one, a typical one in a Discover lawsuit, Shazam. So this is the linchpin for a couple reasons. Number one, you'll see it's number 7 and it says wherefore. So it's the linchpin to me because it's referring to the terms and conditions of a contract that's attached to the lawsuit. The A is usually not. It's usually some affidavit, or B, it is a contract that is a general contract. So take the good and the bad. The good of it is you can take the governing law and go, hey, look, court, they want us to abide by this contract. Here we are in Montana, and it says we got to be in Delaware, yet they're calling me a breacher of a contract they themselves are breaching. And you see the wherefore clause? That's, every lawsuit has a wherefore clause, meaning after all we've said and done in the previous paragraphs, wherefore plaintiff respectfully requests a certain amount of money in favor of Discover Bank C/O Discover Products. That's not an entity. Go look for that entity. There is a Discover Products Inc., and there is probably, and I know that sounds like I'm being facetious, there's probably a Discover Bank, but those two entities are part and parcel of a larger securitization. It's called Discover Holdings. There's several names that you will see in this video. Let me put up 2. The major part of the trust here is Shazam. That's usually where all the securitized debt of Discover goes to, or some iteration of those names, -1, -2, series -3. So look for that in your search, your ChatGPT search or Google search. But there's no contract attached for them to say you applied, that they apply the terms and conditions that you're breaching if you have not signed that contract, or that is not your original contract. They try to get away with that stuff because they're thinking default and they want to present to the court without you there. Hey, look, they defaulted and here's the contract they breached. So you're building that affidavit in your that counter affidavit, and that is part of your answer. Remember, we build a counter affidavit, it drops into the answer, it drops into the affirmative defense. If you do a counterclaim, it drops into the counterclaim. If you get a motion against you for summary disposition, drops into your response. That counterclaim, if built nicely, will follow you all the way to trial. That is your blueprint for every response. And by the way, you can go on the offense with this. You can say, look, here's their lawsuit, here's our counter affidavit, here's our answer, they still haven't met the burden of proof, counterclaim to me, please. So there's lots, it all is based upon the counter affidavit. Build that counter affidavit, regardless of whether your state requires it or not, and some do, so be careful about that. So what happens when they do? You know, you always hear me say, hey man, let's put up that question. What happens when they mention the word debt, Shazam? You always say, they never use the word debt. Well, suddenly Discover Bank is the first that I actually see them talking about the debt. And here's the first paragraph in that complaint. Shazam, Discover Bank is the original creditor and owns the rights to this debt. Plaintiff has not assigned the rights to this party. They're talking to me. I've done enough of this stuff. I know the attorney that wrote that. He's talking to me. He's trying to cut off a lot of work I'm going to make him do, or when he tries to do a summary motion against my client. So, okay, we'll take him at his word, but oh boy, look at what he puts at number 4. Number 4, Shazam, he is saying that Discover Bank is the only entity here, but here comes Discover Products Inc., successor by merger to DB Servicing Corporation. Why are all these entities in this thing if they are the only debt person that owns the debt and they're the only creditor? Let's put up a couple of more. Shazamsky, and as you can see, it's all about an account. It's all number 5 says an account. Number 5 talks about an account. Number 7 talks about an account. It's all about, number 8 talks about the account. It's all about the account suddenly. Why doesn't it just say debt, 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 debt? Because this has been securitized regardless of what they say. Again, they are saying, and by the way, that's a misrepresentation. Discover Bank is the original creditor. True. Owns the rights to the debt. Partly, when a debt is securitized, it is now owned by the entity that is the trust. Otherwise, the bondholders, what security they have for the money they're giving the trust to receive their money back? So it is sort of a true statement that they own the rights. They own some rights, the rights to collect on the debt. They're nothing more than a servicer. Plaintiff has not been assigned the rights to this debt to any, has not assigned this rights to this debt to any third party. That's not true. By the very definition of securitization, they could wiggle worm and go, well, we didn't sell the rights to collect on the debt, but those rights actually come from the securitized trust through what's called, as you've heard me reference, the pooling and service agreement. Pooling and sales agreement. That's what determines what the trust does and how it does it, who collects, how to receive the money, who do we give the money to. So lawyers fast and loose with the words. That's what they do. So that's the only time I've ever seen debt in a lawsuit, but it ends up they sell themselves out by calling it an account. And in that same lawsuit, they use what's called the mini Miranda provision. You've seen the mini Miranda provision in lawsuits against you, indefinitely, hopefully in letters against you, or you got a lawsuit. Here's what it looked like in that same lawsuit we were just talking about. Shazam. Therefore, plaintiff requests a judgment of a certain amount, and they then say, thank you. I always say thank you to them. This is an attempt to collect a debt, and any information will be used for that purpose. This communication is from a debt collector. You cannot say you own a debt, but you are also a debt collector. But Parker, isn't the law firm putting this on the lawsuit? Therefore, the law firm is saying that, but the law firm is not a party. So they cannot make any conversations with you. If they do, then it becomes a collection communication. Discover does not want that. Discover has the immunity. Citibank, JP Morgan, all have an immunity under the FDCP of not being subject to the Fair Debt Collection Practices Act and not being regulated by it. But here's what's going on here. The law firm wants the words on there to protect itself. It's going to protect itself and then its client, my opinion. But does Discover know that this is on there? They better, because it's in their name. And Discover wants it on there, in my opinion, to scare you into thinking a debt collector. Remember, lawyers, they play fast and loose with the words. Well, they will end up going, no, it wasn't. It wasn't Discover, it was us, we put it on there. Are you a party? No. Then you are an agent for Discover. So Discover wanted that on there. And Discover is breaking several laws by saying we're debt collectors when they're not, but at the same time saying you can't sue us under the FDCPA. So they can't have it both ways, and they know that. So put that in your counter affidavit. Very briefly, 1692 GD protects law firms or law firms from being pursued as debt collectors because for a debt collection to begin, it has to be initiated. So that first letter you received from debt collectors is an initiation, which under the FDCPA requires them to send you all your rights. D says sending a lawsuit is not an initiation to start the process. But if they use it like they're using it here, they are losing their immunity, if you will, and that is a debt collection communication. How do I know that? Because it says this is an attempt to collect a debt and any information will be used will be obtained, will be used for that purpose. So that is an initiation, that is a debt collection communication. So I think Discover knows it's taking a chance by scaring you. Your knees are knocking now, oh shoot, while at the same time claiming to be immune. They can't do that. So several laws are broken there. But again, they both, the law firm and the creditor, want that on there to scare you. But that eliminates their first paragraph that says, we own the debt. You can't have it both ways. If you want us to believe the lawsuit, you just contradict yourself, and that's a violation of the FDCPA, specifically 1692 EA1. Check it out. In your answer, so attach this video onto collectionstoppersolutions.com will be several things incorporating everything I'm telling you, everything I've told you from other Discover videos, and it's all about the securitization. All those things in it, DB servicing, Discover products, that's a hint and a half for you that there is a process, a securitization process here. It's a fine line. As we do more of this, as you do more of this, as we all poke the bear of securitization, which they really are doing, it will behoove the debt collector and the supposedly immunity allowed creditor to talk more about the securitization. This is that. They keep trying to say a little bit about securitization without saying too much, but it's yours to explore and manipulate the same way that they're going hard and fast with the loose definitions. You speak the truth in your counter affidavit. So build your counter affidavit on all this information. I have attached to this membership website for your pleasure review a lot of stuff. Several answers incorporating everything I just said, those first 5 things, several counter affidavits that you can use again for your state law and facts. All the answers and counter affidavits are in Word. I've got a couple of Discover lawsuits on there only so that you can see, maybe it's the same as your own, maybe it matches up, and then you can use my answer. Again, my templates are there as a head start, as a skeleton. You just need to put the muscles and the ligaments on it. But it's a great way to start this thing. I'm not just offering you, here's an answer, deny, 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 thank you. I want you to be intricate in your building of the counter affidavit, because the counter affidavit talks to the court. It talks to somebody filing a motion against you. It talks to the lawsuit. It is your counterclaim. Exhibit 1, Exhibit 1, Exhibit 1, Exhibit 1 of your defense. Don't forget that. Attached to this, I'll also have securitization and creditor validation letters. Use them. If there's a debt collector involved, they have to validate. And when you say you're a debt collector, attempting to collect a debt, and you're going to use information they learn from you against you, heck, get in there and say, yeah. And some of my letters say, you said you're debt collectors, so could you please validate the debt? Let's say nothing happens from that, and they go ahead and sue you. You can show the court, by virtue of the fact that you attempted to work this out, you asked them to follow the law. Well, they're creditors. Your Honor, look right on the lawsuit. It says we are debt collectors. And then you can get in, if you want, to that debate, but it's only going to benefit you. I always talk about young attorneys that come after me that want some stuff from me just to be a pest or annoying, and they will file a motion for some BS thing. I love that, because now it's a free shot. They invited me to court to just spouse, to talk about my case and how bad their case is. And sometimes you can see the guy cringe. He's like, why did I do this? And that's what you need to do. When don't ever fear a motion or something like that. It's your chance to speak, to show your case, to educate. And that's what I always do when I'm talking to a jury. I just keep repeating the same things. I educate and I wait. As I said in other videos, sometimes I'll see the judge writing down what I have to say, and then the next case, next motion or something in front, he goes, oh yeah, this is the case where they didn't prove the burden and they claim to be debt collectors. He's reading from his notes, so keep repeating it. through your counter affidavit. My show notes will be on this video. That's so you don't have to look at this face all the time. You maybe put it on Buzzsprout or Spotify, and this you can look at the notes. But whether you want to look at my face or not, I do hope you like, love, and subscribe. I just love doing this. I hope that comes through. I try to give you as much information as I can. The membership and my channel are all blowing up. I feel like I have to do more for you now, and that's why I'm trying to get out as many videos and a couple of shorts here and there. But like, love, and subscribe, and we'll keep bringing the good stuff. Go get them. Thank you.